third panel continues our discussion about tribal issues. Our panelists are Mr. Ron Levine, who was introduced during our first panel, Mr. John Benzunis, did I pronounce that correctly?
Correct.
And Mr. Michael Andrews. Mr. Benzunis is the Second Circuit Representative and Vice Chair of the Probation Officers Advisory Group. He began his professional career as a United States probation officer in the District of Vermont in 2000. In 2008, he was promoted to a sentencing guidelines specialist and later promoted to a supervisory United States probation officer in 2014. He holds a Bachelor of Arts degree from Marywood University and a Master of Arts degree from the State University of New York at Albany. Mr. Andrews is the chair of the Victims Advisory Group. He currently serves on the board of directors for the DC Crime Victims Resource Center, as well as the advisory board for the Maryland Crime Victims Resource Center, Inc. He has over 15 years of experience in victims' rights advocacy. He has a law degree from Roger Williams University School of Law and an LLM from the George Washington University School of Law. Mr. Levine.
Mr. Chairman, the HAG supports the Commission's recognition based on the recommendations of the TAG that tribal court convictions should not be assigned criminal history points and that only some, but certainly not all, may warrant consideration for an upward departure. We make the following comments and recommendations regarding the amendment of 4A. First of all, as regards upward departures based on tribal court convictions and consideration of the proposed application 2C factors, we would recommend a modification to the effect that an upward departure would be barred absent a threshold finding of either the absence of due process rights as explained in the amendment or a conviction based on the same conduct that formed the basis for another conviction that entered into criminal history. So we think those threshold considerations are important factors for a sentencing court to consider up front. Similarly, as regards application note 2C, it currently reads in that preamble to the factors that the court may in addition consider relevant factors such as the following. We would recommend a modification to that language that the court should consider the presence or absence of these relevant factors. Again, we think we want to emphasize, it needs to be emphasized, a consideration of the reliability of the conviction as a basis for the departure should be something the sentencing court should be thinking about first and foremost. As regards court protection orders, the PAG supports defining the court protection order phrase to clarify that it includes tribal protection orders which meet certain due process requirements. Again, we recommend a change in the language to the proposed amended application note 1D to make clear that the due process requirements of section 2265B must be met. The Commission's current proposal, as we read it, reads that the court protection order means any protection order as defined in 2265 sub 5 and consistent with 2265 sub B. The phrase consistent with in the context of due process rights appears to afford some latitude which may not be intended. And so we recommend that the language read that court protection order means a protection order that meets the definition of 2266 sub 5 and that also meets the requirements of 2265 sub B. Finally, HAG does not support a general Chapter 3 adjustment for violation of protection orders. We don't think an adjustment is needed in the bulk of cases in which this may be of concern. The assault and the threat-related guidelines in Section 2A of the guidelines carry extremely high offense levels as it is. They often have an applicable offense adjustment for degree of injury or injury to a partner, and some do contain already a provision relating to protection orders. Thank you again.
Mr. Benzunis.
Judge Pryor, members of the Commission, it's a privilege to be here representing the Probation Officers Advisory Group. With more than 500 tribal nations across the United States, U.S. probation officers are well acquainted with the richness and diversity of Native American culture and the unique sentencing issues that occur within Indian country. In preparing for this testimony, POAG reached out to colleagues working in high concentration tribal areas. And it is clear that our agency works hard to foster positive relationships with tribal nations. These relationships are essential to our ability to gather information in the sentencing process and to effectively supervise individuals living on reservations. In evaluating the Commission's amendment to 4A1.3, POAG is generally supportive of the proposed commentary. However, before discussing the amendment, it's important to understand the realities of gathering records in the field. As the primary record gatherers in the sentencing process, U.S. probation officers often face challenges obtaining official records in tribal areas. Some districts reported working with over 20 different tribal nations that demonstrate varied levels of responsivity. Tribal arrests and conviction records are rarely revealed in automated record queries, which require officers to coordinate directly with the tribes. While some tribal nations are very reliable, making records either available by mail or email, others require officers to physically travel to the location of the reservations, which can be hours of travel. Other tribal courts are reported to be completely unresponsive. Feedback indicates that some tribal areas have modern automated systems, while many others rely on non-automated, non-standardized handwritten notes that require manual searches through paper files. Officers indicate that records often lack clarity with regard to charges, findings, guilty findings, time spent in custody, and attorney representation. Tribal courts also range from having systems to be supported by law-trained attorneys and judges, tribal bar associations, to courts being operated by lay people. It's important to understand this landscape to appreciate the challenges district courts have in evaluating these tribal court proceedings. Officers surveyed by POAG describe common characteristics of Native American criminal history profiles. First and foremost, alcohol-related presents are unfortunately very common. They range from public intoxication and disorderly conduct to DWIs and violent assaults. Mere possession of alcohol is unlawful on many reservations. Tribal police often use jail as a de facto detoxification facility. At the extreme, a subset of Native American defendants demonstrate patterns of purposeful, violent conduct, many times domestic in nature, with histories of unlawful possession and use of weapons. With regard to the proposed amendment, POAG is in favor of subdivisions C1 and C2, but we do not believe that they should be threshold factors for upward departure. While POAG believes that due process protections are an important factor, they should not be determinative given the diverse patterns of practice in tribal courts and the varied factual scenarios presented. POAG also supports subdivisions C3 and C4 in the evaluation of tribal court proceedings. Scoring rules for prior federal, state, or local convictions need to be a guiding factor in determining evaluation for upward departures. Given the characteristics of the Native American criminal history profiles, rules associated with recency, treatment of minor offenses, and double counting all need to be consulted in determining whether and how far to upwardly depart. Lastly, POAG is opposed to the adoption of subsection C5. We understand that some tribal courts have sophisticated systems that adhere to due process considerations. The creation of these institutions is rightfully a great source of pride for many tribal communities, and the commentary is a reflection of that pride. However, POAG is concerned about potential disparity that may be wrought by this commentary. Could result in some tribes being treated differently than others. We believe that district courts already have the ability to consider the spirit of subsection C5 within the provisions provided in C1 and C2. We have no issues with the definition of the court protection order. We think it provides increased clarity. It also provides explicit authorization for district courts to consider court protection orders issued in tribal courts. So with that.
Thank you. Mr. Andrews.
Thank you and good morning, Chairman Pryor and members of the Commission. Thank you again for this opportunity to be with you this morning on behalf of the Victims Advisory Group. The Victims Advisory Group, just for background, are made up of professionals that include former prosecutors, attorneys, former probation officers, law professor, and respected clinicians in the field. Commenting on the recommendations from the Tribal Issues Advisory Group to the Commission, I would say is near and dear to me for several reasons. First, It was this commission's idea back in 2014 through the recommendation of the VAG to have the Tribal Issues Advisory Group. And it was Chairwoman Saris at the time with consultation from many members here. And I just first want to say thank you for that. I think that provides the clarity that tribes need in terms of playing in the field of sentencing. I recall back then there was a lot of discussion about tribal court protection orders. There was a lot of discussions about convictions and how they were going to be played. The issue, of course, with full faith and credit and how that was going to be enacted with tribal governments. So from a personal standpoint, I think it's just amazing that we're here today talking about some proposed amendments. I obviously want to shamelessly thank Judge Erickson for his leadership during the tenure as chair of the TIAG and his continued leadership, as well as Kathleen Grilly and Ken Cohen, who are also part of that dynamic. So I wanted to at least mention them and their support. Regarding the tribal issues, I'd like to focus my comments regarding factors for the district court to consider when deciding whether to depart under 4A 1.3. In order to assist the commission, I'd like to touch on 3 of the 5 factors. Factor 1, the defendant was represented by a lawyer, had the right to a trial by jury, and received other due process protections. I was present during the first or the second panel, and I'd like to, of course, remind the court about the Indian Civil Rights Act of 1968, which, by the way, turns 50 years old this year. It's a seminal piece of Indian policy legislation. And what ICRA allows for is that the accused does not need to be represented by counsel. It is not part of the U.S. Constitution in that regard. ICRA was a standalone that gave tribes inherent rights by the Congress. I'm going to talk about the plenary power that Congress has over federal Indians. I think that's important if we're going to add an additional requirement that tribes have to have a lawyer trained. I would say, again, that's a conflict of what ICRA stands for. The second part supports this, and that was a recent case, U.S. v. Bryant, also supports and reaffirms that the Indian Civil Rights Act, with regard to the use of prior convictions as a predicate offense in terms of prosecution, is also constitutional. As the court recalls, the defendant was an enrolled member of the Northern Cheyenne Nation and had several tribal court convictions that occurred without having appointed counsel representing him. The Bryant court held that those convictions were still valid under 18 U.S.C. 117A. Therefore, the VAG recommends that Factor 1 be modified to include that the defendant was afforded the same rights under the Indian Civil Rights Act and spell it out. The second factor of the commentary is whether the tribe was exercising expanded jurisdiction under TOLOA of 2010. Another piece of legislation that's also near and dear to me. I know the Congress is working on the reauthorization of TOLOA as we speak. However, I would be mindful to acknowledge that there are only, of the 573 federally recognized tribes, which is up from 567, only 6 tribes today are using the TOLOA expansion of sentencing capability. So if we're going to use Factor 2, I would say that sufficiently is going to limit the amount of tribes that are going to be able to participate or play in the same space for sentencing consideration. Certainly this does not mean that the rest of Indian country and the tribal courts that exist today do not have lawyer-trained attorneys. I'm not saying that at all. It just simply means that those non-TOLOA expanded tribes fall under ICRA, the Indian Civil Rights Act. Therefore, the VAG recommends that this factor be limited in scope. The last factor, which I understand has taken a lot of the discussion, is whether or not the tribal government had formally expressed a desire that convictions from its courts should be counted for purpose of computing criminal history points pursuant to the guidelines. It is clear that this amendment has significant meaning, and I think we've all touched about the important role of sovereignty for tribes. And I'll just sum up in about 30 more seconds. The Commerce Clause of the U.S. Constitution provides that Congress shall have the power to regulate commerce with foreign nations and among several states and with Indian tribes. It's Congress's plenary power over the tribes, over laws. So when Congress has spoken through legislation, through enacted statutes, such as 18170A, I would surmise that Congress has acted, and it does not pierce tribal sovereignty, but there is an acquiescence of inherent power that the federal government has. So therefore, I would say that tribal sovereignty is not pierced, and therefore, really relevant factor 5 really is not needed in this particular analysis since Congress has spoken. Thank you.
Hey, questions? Judge Breyer, do you have any? All right, thank you very much. We're going to take a 15-minute break, so we'll reconvene at 10 minutes until 11.